minutes is run, you'll hear a sound, and I'll probably try to warn you as well. Well, we're ready to proceed then if you are.
This is a straightforward case. The defendants, and specifically defendant Pendergrass, filed 2 fraudulent liens against our properties. The liens are not supported by any judgments whatsoever. This is a very sophisticated crime in the way they have done it, because they tied it to a prior judgment that Judge Terry Nestor from Hamilton County had issued. In fact, if you look at exhibits 5 through 10 of the complaint, you will see that the certificates are imprinted with the number of that one case. They're also imprinted with the name of defendant Gregory Berberic, or Beveridge. Sorry, mispronounced it. The judgment liens do not have any supporting judgment. They were filed illegally. They were filed with intent to encumber our properties in Warren County. And in our opinion, they were filed with intent to harm the defendants, the dismissed defendants in that case from Hamilton County. Judgment liens, as we know, are highly negotiable. And in this case, by filing the judgment liens, they were granting themselves basically a free rein to sell the judgments. In fact, I was contacted by multiple judgment companies that wanted to buy the judgments from them and sell it to me for 50% discount, including one called Mayfair. To put in perspective, this is what happened. Defendant Berberic in 2017 sued me over a property dispute. That case was settled. Subsequent to Berberic suing me, he dismissed himself from the case or dropped out of the case, and defendant O'Connell took over the case. Yeah, this is case A1705644 in Hamilton County. Once defendant O'Connell took over the case settled. He took over the case sometime in March of 2018. The case settled in August of 2018. Before the case settled, defendant O'Connell had the court appoint a receiver. The receiver hired defendant Pendergrass, that's the lawyer. Defendant Pendergrass is not a receiver, was not a receiver, and is not a receiver now. He's just a lawyer for the receiver. After the case settled, the judge that appointed the receiver retired. He lost the election to Judge Nestor. But the case was dismissed. We were all gone. All the defendants were gone. Defendant O'Connell and Pendergrass went back to Judge Nestor, the newly elected judge, and began what they now call a receivership action on the dismissed case. The receivership action went from February 2019 through September 2019, at which time Judge Nestor issued an illegal judgment against the dismissed defendants. And that is the judgment that is imprinted on the liens. That judgment was appealed, it was reversed prior to me filing this lawsuit.
Mr. Fontain, I want to make sure I understand. Is your argument that the certificates of judgment, the lien, was illegal because the First District Court of Appeals subsequently reached the decision it reached with regard to the receivership fees, or is there some other reason?
No, they were illegal from the beginning.
Why were they illegal from the beginning?
There was no judgment to support them. I only put in the situation with it, setting aside of that judgment from Judge Nestor, because it's imprinted. The case is imprinted on the liens. But the judgment in and of themselves had no judgment. The false liens in and of themselves did not have a judgment to rely on. There is no judgment issued by any court that supports those liens. Specifically, Mr. Berberic represented H&R Cincy LLC, who is the plaintiff who sued me. Mr. O'Connell represented H&R Cincy LLC, who continued the litigation. There is no judgment issued by any judge in the name of H&R Cincy LLC, by any court. If you look at the judgment liens, Exhibit 5 through 10, the judgment liens are in favor of H&R Cincy LLC, when there is no judgment whatsoever for H&R Cincy LLC. Back in April of 2020, I sent an email to all the parties demanding, this is months before I filed the lawsuit, demanding for the receiver, for the judgment lien to be released from the record. It fell in deaf ears. They didn't do anything about it. So it forced me to file the lawsuit. At the end of the day, the fact remains that on September 25, 2019, Defendant Pendergrass walked into the courthouse in Warren County and filed not one lien, but 2 liens against the dismissed defendants in that case in Hamilton County without any judgments. Each lien for $79,000, almost $80,000. This was September 25. Normally, the way I understand it is that when a judgment is issued by a court, the first court that issued the judgment is where the judgment lien is filed. And then it gets propagated to other courts. They did it backwards here. This is how sophisticated the fraud began. What they did is, they didn't file in Hamilton County, which is supposed to be the county where the judgments came from. They went to Warren County first. And once Warren County certified the judgments on September 25, 2019, then on October 7, 2019, they took it to Hamilton County. Now, they look real. I have had to battle with collection agencies and explain to collection agencies and law enforcement the illegality of this sophisticated crime. That's what's, because when you look at the judgment liens, at the certificates, they look real. They look like Judge Nestor issued them. They look like they were issued in a case, in a legitimate case. They look like Mr. Barbaric is behind it. They look like Mr. Pendergrass is behind it. And they look like Mr. O'Connell is behind it. Why? Because they're issued in the name of their client. When there is no judgment, period. And they cannot produce one. I have been asking since early 2020, produce a judgment. Let me see it. And that's how we got here. Very sophisticated crime. And I'm going to say this to you, Your Honor. This has caused us so much trouble, you have no idea. I walk around with a credit card that has $100,000 credit limit. If these judgments, these fake judgments, would have reached the credit agencies, I would have lost my 850 credit score. I can call any bank and borrow $1 million on my signature. And when they filed these fake judgment liens, they did it on purpose. They did it with intent to cause harm. There is no judgment on behalf of H&R Cincy LLC anywhere, and you're not going to find one. And I'm suing them because of that. Not only have they done this, but they have continued the litigation. It seems like this is what we did, this is what we are going to continue to do, and there is nothing you can do about it. Filing a judgment lien or certificate of judgment lien on anyone's property is a crime, and it's penalized with imprisonment. And I'm going to say this, no one is exempt, particularly judges. We know this, that normal people get hit by fake judgments all the time. They advertise on the radio all the time. Judges specifically are hit by fake judgment liens all the time. This is not unusual. I would like for the defendants to show me the judgment. We're here now. Show me the judgment. I want to see the judgment on behalf of H&R Cincy, LLC. I want to see the judgment, because there isn't any. Mr. Pendergrass' attitude is, well, you know, what the heck? It's a moot issue. Mr. O'Connell's attitude is, hey, there comes Marcus Fontain again making noise. Mr. Barbaric says, hey, not mea culpa, I have nothing to do with it. I even invited Mr. Barbaric, if you're not involved in this fraud, let's go to either the United States Attorney's Office or to the prosecutor's office, and let's file charges against who prepared these fake certificates. And he refused. Until today, he refused.
You did hear that your time ran, your 10 minutes, but you can keep talking. You just are now getting down into the 4 minutes and 3 minutes.
I'm just going to reiterate.
Okay.
There is no judgment on behalf of H&R Cincy, LLC, issued by any judge, anywhere, and they cannot produce one, and no one can find one.
All right. Are there any questions?
No.
All right, thank you. We'll move next to, amongst the three of you.
Zach Prendergast, Your Honor.
All right.
I think I've been elected to go first.
Forgot the short straw.
Thank you, Your Honor. May it please the court. My name is Zach Prendergast. I was the counsel for court-appointed receiver Project Properties, also counsel for April Lane and myself, pro se, in this case. I guess, just getting right to it, I heard the where's the judgment a million times. On September 12, 2019, Terry Nestor entered a judgment in the Court of Common Pleas, Hamilton County, Ohio, that basically awarded us $80,000 in various receivership fees, expenses, and costs. So pursuant to that judgment, we went ahead and certified the judgment in Hamilton County, and then also asked for it to be, issued to Warren County too. So we followed the proper process. There was a judgment saying that we were owed so many dollars. This is the subject of already 2 Court of Appeals decisions. I mean, I think it's just the facts are what they are. It's already been reviewed twice and published. So getting to the merits of the motion to dismiss, here I guess there could be 2 issues. One is maybe a threshold issue for the appeal. The fact that I've actually released the certificates of judgment since this case was filed. And the reason I did that is because the first Court of Appeals cases, remanded back to the trial court to just examine the issue of whether the amount that was assessed to Mr. Fontain was correct. The trial court has since determined that he was a dismissed defendant, and therefore, he should not have been taxed with court costs. At that time, there was a cutoff at February 11, 2019. So as soon as that decision came down, we went and released our judgments. We never executed on the judgments. We never did anything besides filing on the judgments. So I guess since the judgments have actually been, the certificates of judgment have actually been released, and I would argue that this appeal is essentially moot. But even beyond that,
Can I just clarification on timing? I thought the first Court of Appeals decision was in February of 2021, but the certificates of judgment were released in August.
Well, it was remanded back to the trial court, and it took that long for the trial court to actually have a hearing and basically issue a decision on the disposition of the fees and costs that have been awarded. And so that was, we held a hearing on that, a decision came down, that basically said we believe that Mr. Fontain should not have been taxed with the fees and costs. And so we went ahead and released after that. It's important to note that that was the only issue that the appellate court took any exception with. The order itself was never vacated. None of the findings of fact and conclusions of law in the order, other than the court costs, were vacated. That order, goes on for several pages, saying that the receiver did everything it was supposed to do, that it acted properly in every way. Essentially released and exonerated the receiver from any kind of liability or anything like that. So that is a matter of law at this point. The First District Court of Appeals, in both the February case and then the August case, have both reaffirmed that order except as to the issue of the court costs. And that sort of gets to the second thing here, which is I think the Court of Appeals, the First District Court of Appeals, did a really good job of covering, is that this is essentially a case where Mr. Fontain is just trying to relitigate the receivership case. It's a collateral attack on the orders that released the receiver. Sort of implicates two things. One is there's pretty clear Hornbook law that you can't sue a receiver in the state of Ohio without actually going to the appointing court and getting leave to sue the receiver. That did not happen here. And the second thing is that you cannot collaterally attack another judgment in the state of Ohio. You can't just say, I want to redo, so I'm going to file a case in another court of common pleas asking for them to overturn a prior court's judgment. So those are both things that have occurred here. The First District Court of Appeals in its August case, covered these, I thought, very well and very much detail under essentially the same facts. This happened where he already filed, got a bad decision that he was not happy with, so he filed another case in the Court of Common Pleas, Hamilton County. That case was dismissed, just like this case. That case was upheld on appeal. It's essentially, Groundhog Day. He's doing the same thing where he filed a case in the Court of Common Pleas, Warren County, where he wants to relitigate the Hamilton County case. So, from our point of view, one, we think it's moot because the certificates of judgment that seem to be the problem here have been released. Two, he never went to the appointing court and asked for leave to sue the receiver. So that's essentially a threshold issue that would be grounds for dismissal. And three, he's essentially trying to collaterally attack the judgment of the Court of Common Pleas of Hamilton County here. So none of which is permissible, all of which were grounds for dismissal of this case. And so I would ask that the court uphold Judge Peeler's decision in this case.
You say the lien has been released.
Mm-hmm.
Was the judgment satisfied?
No, I released it based on the fact that when the trial court reviewed it on remand, the trial court determined, based on the fact that Mr. Fontain had actually been dismissed pursuant to like a settlement agreement, that it just said at that point, the judge did not have jurisdiction to tax them with court costs. And then they remanded it and they reviewed whether he owed any money prior to the dismissal on that case. And the judge determined that all those obligations had been met. The vast majority of the fees that had been incurred were after that February date. So when the trial court said this is, we don't think he owes anything anymore, that's when I went and released the judgment lien.
All right. Any further questions for Mr. Prendergast? All right.
Thank you, Judge.
Thank you.
I'll switch his thoughts.
Mr. O'Connell.
Good morning, Your Honors. Brian O'Connell, law firm Strauss Troy, representing H&R Cincy Properties, Harjinder Sandhu, Jarsim Sandhu, and myself. May it please the court. It should not have been that hard. It really should not have been that hard for Mr. Fontain to do what Judge Peeler asked him to do. Judge Peeler instructed Mr. Fontain to provide a clear statement of his claim against me and my clients. He was given more than 2 weeks to do that. Judge Peeler made clear in that order that Fontain's failure to comply could result in dismissal of the case. So it should not have been that hard. The judge was very clear in terms of what he wanted. The only reason that it was hard is because there was no basis for the claim. In fact, as Mr. Fontain conceded repeatedly in the briefs he filed before this court, in order for him to comply with Judge Peeler's directive, Mr. Fontain would have had to fabricate, and that's his word, not mine, would have had to fabricate claims against H&R Cincy Properties and my other clients. Mr. Fontain, therefore, did not comply. What he filed in response was not responsive to the judge's request. At that point, Judge Peeler was fully within his discretion to dismiss those claims with prejudice, which is what he did. The case law is clear that once the plaintiff has been given notice and given 14 days to file a more definitive statement, it fails to comply, the judge can dismiss it with prejudice. That's as simple as the case against me and my clients is. I won't reiterate all the very good points that Mr. Pendergast mentioned in terms of collateral estoppel, in terms of the fact that we have a First District Court of Appeals case now directly on point in the first lawsuit that Mr. Fontain filed against myself and my clients. Those, in my mind, are conclusive. Although, again, with respect to my client, you don't even have to get to that level of detail because it is so simple. because Judge Peeler instructed Mr. Fontain to do something, and he simply ignored that request. Because it's that simple, I don't have a whole lot else to present to your honors. I'm open to any questions you have. Perhaps the one other point that I will make is I think just from listening to what you've heard already here today, this really underscores the problem that is created when you have somebody filing a lawsuit, or in this case repeated lawsuits, all of which relate to and arise out of and try to generate claims out of a prior lawsuit. That's exactly what the collateral attack doctrine is for. So you're not out there relitigating what has already been litigated, trying to bring a lawsuit about a prior lawsuit. It gets that messy. So if anything underscores the importance of that doctrine in the law, I think it's this case. Also underscores the risk where you have somebody bringing lawsuits about lawsuits, that you're bringing lawsuits now against counsel, which is, it's one thing that we all as attorneys out there have the risk of getting a bad result and being sued by your client for malpractice. Now, apparently, if you get a good result for your client, you have to worry about being sued by the other side. That isn't the way it should be. And I think collateral attack doctrine is something that protects against that. But here again, because of procedurally how the claims against myself and my client were disposed of, you don't even have to get to that level. So I would ask you to affirm Judge Peeler's dismissal. Thank you.
Let me ask before you sit down, does H&R Cincy have judgment liens against Mr. Fontain?
It does not.
Okay. Do you have any pending actions against him yourselves, or is everything that was going on between the two of you as parties resolved in Cincinnati?
We have not brought any claims against Mr. Fontain. However, Mr. Fontain still has two pending lawsuits against myself and my client. One is the United States District Court for the Southern District of Ohio, which Magistrate Lipkovitz has stayed. The other is a more recent case that he filed again in Hamilton County that's been assigned to Judge Heekin. We're in the process of filing a motion to dismiss that claim. Currently, though, again, we have not filed any lawsuits against Mr. Fontain.
All right. Any further questions for counsel?
Thank you, Your Honors.
Thank you, Mr. O'Connell. Mr. Burberg?
Thank you, Your Honor. I'll try to live up to my 30-second time limit.
You have a little more time than that.
I filed the original lawsuit against Mr. Fontain with an E. He describes this as a sophisticated crime. Mr. Fontain is a very sophisticated criminal. He's got a criminal record in California. He's been deemed a vexatious litigator by the California courts, and he's continuing it today with...
Is that in the record below?
It's in the trial court record. It's filed in the complaint.
In the Warren County trial court, or?
The complaint in Warren County used as an exhibit the original complaint, I do believe. It had 100 pages of exhibits. I don't know for certain.
Well, a complaint is one thing. A judgment entry making a finding to that effect that he's a criminal in California is another.
Okay. Well, Your Honor, it's very simple. I filed suit. My client dismissed me, brought in Mr. McConnell. There was no issue about that. At that point, Mr. Fontain reached out and engaged me, and I said, don't send me any more emails. I don't want to hear anything from you. I don't want to be involved. I'm no longer involved in the lawsuit. Subsequently, there was a settlement agreement that went on that released any parties and their attorneys. I filed that with Judge Peeler, along with my dismissal entry reference to the settlement agreement that released all attorneys, and the email that said, don't contact me anymore. I have absolutely no idea and no control over the clerk's office in Hamilton County. So when they caption a CJ, I wasn't involved. In fact, you heard Mr. Fontain start his preamble by referring to Mr. Pendergast, who I just met today, that he went to the courthouse and filed the precipice for issuance of the CJ and paid for it, which I, again, reminded the Judge Peeler that they filed the precipice, they paid for it. I had no involvement. So I think Mr. Fontain somehow wants to wrangle me into this case and turn me against his opponents so that he can get my legal aid. Like when he threw out this, let's go to the U.S. District Attorney and go after these guys. I don't want to be associated with him. I have had no role in this case whatsoever since the day that I filed my, other than defending myself, since the day I filed the dismissal entry or told Mr. O'Connell that he could sign it on my behalf when I withdrew. So I don't have anything to do with him. I don't want to be associated with him. I wish he would stop suing me. And that's my position.
All right.
Please let me go.
Are there any questions for Ms. Porter?
You have any questions?
All right.
Thank you.
All right, thank you. Mr. Fontaine, we come back to you. You should have 4 minutes remaining of your time.
Thank you, Your Honor. One thing that you didn't hear is that they have a judgment. There is no judgment. All this thing about California and all of that is hogwash. None of it is true. It's a fabrication.
Well, they did say that the judgment they had that became that they think, assert that they had for the $80,000 costs and fees has been litigated further in Hamilton County, and that ultimately they released the lien. So my question of you is the lien still there?
Judge, this is all gobbledygook. Okay,
Well,
this is more fraud on their end.
Okay, I'm just asking, is the lien still?
Judge Nestor did issue a judgment in that case. That is true.
Sure.
In that case. That case was appealed. That case judgment was reversed.
Correct.
That case.
And he said that because he pretty much lost, he had no justification for the $80,000 in the court costs, that he released the lien. So I'm just asking, is the lien still there?
No, Mr. Pendergrass just released it, and he didn't release it because the Court of Appeals reversed anything. The Court of Appeals did not have these liens before it. This has never been argued in any Court of Appeals except this one in Warren County, where the fake liens were filed. What was argued in that court, in the first Court of Appeals, was the illegal judgment that Judge Nestor issued against the dismissed defendants. That's a separate issue. That's a separate case. It's a separate court. It's a separate district. Nothing to do with what they have done here. What they did here is that they piggybacking on that, using it as a stalking horse, they came over here to Warren County and filed 2 fake liens. These are fake. There is no judgment associated with them. They are fraudulent. And they have not produced one. They have not argued about one. What they say is, look at Mr. Fontaine. He's a litigator. He does this, he does that. Well, guess what? Had it not been because I was approached by I think it was called Mayfair Company, about buying the illegal judgments from me, I would have never known about it. How many owners, I own 2,000 properties, how many owners are checking the title to their properties every day? I don't. And I don't know anybody else that does, right? Had I not been contacted by this company about buying this judgment, which, by the way, already became something like $365,000, not $79,000, because they have filed it 4 times, 2 times in Warren County and 2 times in Hamilton County, subsequent to filing in Warren County. The point is this: they're a fraud. They filed a judgment lien on all my properties. They encumbered, in Hamilton County alone, they encumbered almost $5 million worth of properties with fake judgments. In Warren County, we have more than $1 million worth of properties that we own. It was encumbered. We cannot even refinance our house because this judgment, well, now they have been released. Thank you, Mr. Pendergrass. What a generous man are you. They, Your Honor, what they have done here is a crime. If I did this to you, you would have me hang in handcuffs out that door in 1 minute. This is a crime. Nothing to do with me, nothing to do with my family, nothing to do with anybody. Yeah, we were sued. Okay, we made a mistake. Yes, we settled. End of story. It was a year after the settlement that the defendants were unsuspecting. I was in Texas at the time I found out about this thing, because we own a house in Texas. We were unsuspecting that this had been filed. These judgment certificates of lien are a fraud. There is no judgment associated with them, Your Honor. I am so sorry to tell you. They cannot prove it. They didn't prove it. They cannot prove the judgment. Show the judgment. We're still here. Show the judgment. They're talking about Judge Peeler. Judge Peeler dismissed the case improperly.
If you will, your time just expired.
Thank you.
So we appreciate your arguments, unless there are further questions from the panel. Ms. Fontaine, counsel, Mr. Burbick, we will take this matter under advice, render a decision appropriately, and you'll be so advised of our decision.
Thank you, Your Honor.
With that, if you would, as in the prior case, please wipe off the lectern and surfaces that you touched for the next parties. Thank you for doing so. I would, whoever takes Mr. Fontaine's side, he did not wipe down,